Government Business Notice Number 1, standing in the name of Mrs Finocchiaro to present the Police Administration Legislation Amendment Bill 2025, Serial 16.
Chief Minister.
Madam Speaker, I present a bill titled Police Administration Legislation Amendment Bill 2025, Serial 16, and table the explanatory statement. Madam Speaker, I move the bill be read a first time. Madam Speaker, the bill will address two limitations identified surrounding the operation of police powers. The First Amendment overcomes a constraint on police in relation to arrest powers. Currently, police are prevented from entering private premises to effect the arrest of a person who is in breach of their parole conditions or whose parole has been revoked. Section 5G of the Parole Act 1971 empowers police without a warrant to arrest a person who is in breach of their parole conditions or whose parole has been revoked. However, unlike some arrest powers, there is no applicable power of entry in order to effect an arrest on private property. Further, the ability for a warrant to be obtained under the Parole Act is only applicable for parolees located outside of the Northern Territory. In practice, this means that when a parolee is on private property, police will not enter the property to effect a parole arrest. However, if there has also been the commission of an offence, police can enter and arrest the person for the offence and bring the person before the court for both the offence and the parole breach or revocation. This legislative anomaly impedes the ability for police to arrest people who have breached their parole or had their parole revoked. This is clearly contrary to the intent of the parole regime. Persons who are on parole are subject to apprehension if they breach or have their parole revoked. Further, it would be the expectation of the community that the police have the powers necessary to apprehend those persons no matter where they are located. The bill inserts a new section 126 A into the Police Administration Act 1978, which specifically provides police with the power to enter a place to effect the arrest of a person who is reasonably believed to be in breach of their parole conditions or whose parole has been revoked. In line with similar powers to enter for an arrest, police will be able to enter to effect a parole arrest at any time with use of reasonable force and with any assistance necessary. This amendment ensures that police have the powers necessary to maintain community safety by making it clear that police can enter places to effect the arrest of a person who is in violation of their parole or who has had their parole revoked. The amendment will greatly improve police efficiency. The Second Amendment concerns police's ability to conduct proactive operations to ensure compliance with the conditions of a domestic violence order. DVOs routinely include conditions prohibiting a respondent from being in the presence of a protected person or at a location where the protected person resides or is at while intoxicated. These DVOs will also include a condition for the respondent to submit to drug and/or alcohol testing, which is compliance testing, when required by police. These conditions are utilised when there is an identifiable link between the respondent being intoxicated and the commission of domestic violence by the respondent against a protected person. The purpose of these conditions is to prevent future harm from occurring by requiring the respondent to stay away from that protected person unless they are sober. The practical effect of non-intoxication conditions is that the respondent cannot drink with the protected person, cannot drink at the home where the protected person lives, and also cannot return to that home while still intoxicated. Domestic violence rates in the Northern Territory are unacceptable, and a primary focus of the police force is the prevention of domestic violence. One way police can do this is by proactively monitoring compliance with domestic violence orders to identify breaches of non-intoxication conditions before a situation escalates to harm. Efforts to conduct proactive compliance checking have been hampered by a limitation under trespass laws identified by the High Court. This decision prevents police from attending a private residence for the sole purpose of requiring a person to submit to a coercive power such as a compliance test unless there is an express power for police to do so. The bill addresses the High Court's decision of Roy and O'Neill 2020, High Court of Australia 45, by inserting the new section 126 capital E of the Police Administration Act to authorise police to enter onto property in order to locate a respondent to a domestic violence order and require them to comply with a compliance test. This power is specific for the purpose of domestic violence order compliance checking. Entry will be limited to places where police reasonably suspect the respondent may be. For example, the respondent's residence, the protected person's residence, other family residences that the respondent is known to frequent, residences where family tell the police they can likely find the respondent. In practice, police may need to attend multiple locations, and the provision is carefully drafted to ensure the power will permit this. Police will be permitted to enter onto private property, but not to enter a private residential dwelling without the consent of the occupier. Entry into a home where there is no indication of wrongdoing will not be permitted. Rather, police will be allowed to enter the property and speak to occupants to determine if the respondent is present, and if so, require the respondent to submit to a compliance test in accordance with their domestic violence order conditions. I must stress that this power has been carefully drafted to allow police to enter any outdoor parts of the property, such as yards, driveways, carports or verandas, as well as common areas in unit or apartment complexes, such as common hallways or stairwells. Further, it will allow police to remain on the property for such time as is reasonably necessary to verify whether the respondent is present and, if so, to conduct that compliance test. Where a respondent is compliant and there is no indication of wrongdoing or harm, police will be required to leave. This ensures the power is balanced and limited to achieve its intent. While there are limitations imposed on this new power, it does not preclude police from exercising any of their other relevant powers if circumstances warrant, such as the power to enter a premises for the purpose of arresting a person for an offence, including a breach of DVO under section 126 capital A of the Police Administration Act, and the power to enter for the purpose of protecting a person from another person who is contravening a domestic violence order under section 126 capital B(1)(b) of the Police Administration Act. This will provide police with a practical ability to proactively target and monitor DVO respondents in the community and their compliance with non-intoxication conditions. As intoxication is a significant contributing factor to the prevalence of domestic and family violence, the ability to proactively monitor DVO compliance in the community will allow police to more actively address domestic violence by identifying and addressing risk factors associated with intoxication at its early stage, and in order to ensure that the DVO conditions are maintained. These are straightforward and practical solutions that will enhance police operations and enable them to do their job more effectively and efficiently. And Madam Speaker, I'd like to thank the Northern Territory Police Association and their President Nathan Finn, who has welcomed this legislation, Madam Speaker, and the Police Association are a very, very important partner in making our community safe. They represent the vast majority of Northern Territory Police and the concerns that police have. I'd like to quote Mr Finn, Madam Speaker, from an article published by the ABC's Matt Garrick on the 12th of February, and I quote, "It gives us a proactive power to enter the property and make sure they're complying with the conditions of those DVOs and make sure the protected persons on those DVOs are obviously protected." He went on to say, "We need to be able to have those powers to be able to do our job and proactively do our job, to make sure the vulnerable people in our community are being protected by the police," end quote. Madam Speaker, much has been said publicly and in this parliament about family and domestic violence. And I note yesterday the Minister for Domestic Violence made it very, very clear about funding arrangements and the expenditure of the $36 million in the coming year to make sure we're doing everything we can. And our government has a very firm commitment on the table for that ongoing funding. We've also made a very clear commitment to spend that money properly, and that does not involve rubber stamping just whatever Labor did in the past, because we know under Labor, Madam Speaker, domestic violence went up 82%. Shame. And so these laws today provide a real tangible opportunity to make change. It's these types of changes that aren't usually the ones called for loudly in the media by the sector. They're always calling for more money, and that's fine, that's their prerogative. But it is absolutely critical, and as Police Minister, I must emphatically stress that laws play, and the enforcement of laws more importantly, play a very big role in driving down crime, specifically family and domestic violence. So it is not the whole story to talk about more money needed. A very big part of the story is better laws and better police powers, and that is often overlooked in public commentary, much to my despair, because a big part of what can be done rests with us right here in this very parliament. And it is stuff that requires what I like to call the stroke of a pen. There is no money required to make the changes we're proposing today. There is no federal begging or funding needed to secure any deals to do this, Madam Speaker. There's no resourcing allocation required within our police to effect this change. It's literally political will to come into the parliament, drafting appropriate laws and passing it through the parliament. And that's the journey that this will now take over the next month as people can read the bill and we come back for passage in March. And this legislation, this very simple power of entry, will mean that police can ensure compliance. And we know that alcohol plays a very big role in domestic violence. And we know that if someone has a domestic violence order, one of the best things we can do is make sure we support our police to enforce it. There is no point having laws if they are not enforced. And we're seeing a huge impact of the laws we've done, even with our family responsibility agreements and our school attendance officers in different policy areas, because compliance is our focus, because accountability of the individual is our focus. We are seeing the individual take more responsibility. And that is what compliance and enforcement of laws does. It acts as deterrent. And so we are hearing all the stories from families who now understand they must send their kids to school. We're starting to get some traction in just 5 months on that already. Much more work to do, Madam Speaker, not job done. But my very point is, since August last year, we've stood up more than 47 school attendance officers across the territory, and word is absolutely out on the street that you will be fined if you don't send your kids to school, and as a result, people are sending their kids to school. That is my point. When I talk to the youth workers in Alice Springs and they talk to me, I ask them, how are the family responsibility agreements going, of which we've got more than 40 on the boil, Madam Speaker? And they say to me, no, parents understand. Parents understand they've got to look after their kids better. And so it's having a positive impact. This is exactly the same. Powers like the one that I have just introduced, Madam Speaker, allow our police to open a gate, walk around the backyard, ask questions and test someone for what is a legal requirement that they have. The court has clearly determined that this individual is a risk and threat to what is usually a woman or a child, and determined that that person must never be drunk in their presence, must have certain rules to follow. So by giving our police the powers to see that through right to the end, word will get out, Madam Speaker. People will change their behaviour. And when they don't, our men and women in our police force will be there to make sure that the consequences are dealt to that individual so that that woman or child does not have to suffer them themselves. And that is the power of legislative reform. It's off the back of our reducing crime package, Madam Speaker, which in just 6 weeks of coming to government, we passed through the October sittings, all on urgency, unprecedented levels of reform to put the rights of people to be safe above the rights of the offender. And again, in Declan's Law, something we're so proud of. Declan's Law, and I spoke to Samara Laverty just the other day off the back of Declan's birthday. And we know that repeat domestic violence offenders are not having the luxuries they used to have under Labor. Because why should we afford the luxury of freedom to a repeat domestic violence perpetrator? We should not, and we will not. Unlike Labor, who removed mandatory sentencing, made bail a total joke, spinning door out the front of the court. That is over. So if you are a repeat domestic violent offender, you're going to court on the back foot. And we make absolutely no apologies for that, Madam Speaker, none whatsoever. So those laws we passed in conjunction with this, giving better powers for our police, part of our promise to them. That first day of coming to government, Madam Speaker, I looked the Police Commissioner in the eye and I said to him, we have your back. We have the backing of your police. Please tell them we will do whatever it takes to make them feel supported, to make sure they have the powers they need, and to make sure we together reduce crime. And that's what we're doing. And I have been out right across the territory with the front line, learning so much, Madam Speaker. And the number of laws and improvements that they've given to me that we're now working through to bring to this Parliament to make law is really exciting. They're feeling empowered, they're feeling heard, and they are ready. We have put additional 500 people in prison since August. And that policing intensity will continue because people's right to be safe comes first. You cannot have a strong economy, you cannot have kids going to school, you cannot have less domestic violence unless you put people's right to be safe first, and that means we need stronger laws and better consequences. So, Madam Speaker, I commend the Police Administration Amendment Bill 2025 to honourable members. I urge them all to read this legislation, which gives more power to our police to support less crime, less family and domestic violence, delivers consequences to perpetrators, enforces important laws designed to keep people safe. This is proactive policing at its best, something our police could not do under Labor because crime was so out of control, it was react, 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 react. Well, we are starting to be able to ease that pressure ever so slightly on our police and move into a phase over time where we are proactively policing, stopping crime before it happens. I'm very proud of this legislation, Madam Speaker. There is much more to come in this Parliament this year, and we are very proud to stand with the men and women who wake up every day and pull on that blue uniform, leaving their families to go and protect ours. I thank them for their hard work, their service, their dedication to our community. We stand with you, and we look forward to giving you the powers you need to continue to make our community safe.